All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas is now in session. The Honorable Judge Hurst presiding.
Please be seated. Good afternoon, everyone, and welcome to the August 16th, 2022 afternoon session of the Kansas Court of Appeals. Today, we are sitting in Topeka, Kansas, and we are also live streaming online. To my right is the Honorable Judge Stephen Hill, who served on the Court of Appeals for almost 20 years after a few years as a district judge. To my left is the Honorable Gordon Atchison, who served on the court for almost 12 years after a distinguished career in private practice. I am Judge J.C. Hurst, and I've been on the court just over a year after 15 years in private practice. Today, I'm your presiding judge, which means that I have some administrative tasks, not the least of which is keeping the timer. Today, the parties have requested additional time, which has been granted. Each party has 25 minutes to present your case. Because we're streaming online, I will ask the appellant to give a short 30-second overview of the case, for those watching. I'll also remind the attorneys that we have read your briefs, we have reviewed the record, and we have reviewed research memorandum regarding your case. So please consider that when you're presenting your facts to us. I will also let you know that there is no award for using the full time. So if you feel so inclined, no. We may interrupt you from time to time with questions just to be clear that we understand your arguments and your position. So with that, I would like to call the case number 123719, Deutscher v. Hefner. Can the parties please enter their appearance?
Please the court, the corporation, Deutscher and Rottinghouse Corporation and Chris Deutscher appear through counsel Charles Engel and Derek Ulrich. We are prepared for oral argument.
The appellee plaintiff appears, Dr. Hefner appears through his counsel, Roger Walter. We are prepared for oral argument.
Counsel? Would you care to reserve any of your time?
I will reserve 5 minutes for rebuttal.
5 minutes for rebuttal? Go ahead.
As the quick overview of this case, it deals with the breakup of a professional practice of optometrists operating here in Topeka, Kansas. The issues are basically based on contract law between the parties, which had been signed way back in the 1990s. This action all started basically 6 years ago when one of the doctors wanted to leave the practice and be bought out by the corporation. And we are now here for our second appeal after 2 trials with the Shawnee County District Court.
Fantastic. Thank you. Please proceed.
Because we are here on a second appeal, I think it's important that we review the decisions of the prior Court of Appeals panel in the first appeal, in which they found that paragraph 14D of the employment agreement between the corporation and Dr. Hefner, who wanted to leave the practice, are unambiguous and mean what they say, in that not only would a violation of paragraph 14D, which has to do with any kind of competition with the practice by any of the doctors, if that happens, then they would, whether it was a breach, an actual breach, or a threatened breach, they would therefore either be faced with an injunction or any of the other remedies available under the contracts between the parties. And the court found those to be unambiguous and enforceable. So as part of that, the court also found that the employment agreement, which is at the basis of this whole dispute, was crafted by the drafters to protect the corporation's interests. That it was there to protect the corporation and that it would be reasonable to interpret it in that way. Now, part of this is a major fact is there was only one employment agreement during Dr. Hefner's entire tenure with this practice, the one that he signed back in 1997. 2016 is when he decided he wanted to leave the practice and be bought out. That started a negotiation between the parties, which basically led to a point where they said, fine, he offered to receive $100,000 for his interest and shares in the corporation and to be released from his non-compete so he could go practice elsewhere. There was basically 2 full months of negotiations going back and forth, which essentially the corporation conceded to every request that Dr. Hefner wanted, except one, which that was is that he couldn't hire away corporate staff. As part of that deal, it was contingent upon a written agreement signed by Dr. Hefner. However, we did prepare a new employment agreement for Dr. Hefner in that process, which basically would say that he would be paid for his shares and other interests in the corporation on December 1st of 2016, but remain an employee of the corporation through March of 2017. It also would have then released him from his non-compete. All of this was supposed to basically be triggered to go into effect December 1st, 2016. On November 29th, 2016, from the corporate office, Dr. Hefner filed an application with the Kansas State Board of Examiners in optometry to have them approve not only a trade name of Hefner Family Vision LLC, but also a practice location here in Shawnee County. The Kansas State Board of Examiners in optometry is a legislatively created entity by the state of Kansas. That is a municipal corporation. It is charged with overseeing the practice of optometry in this state, which would include applications for a trade name. That trade name.
But if you wanted to practice, you have to get their approval and be licensed through that, correct?
Correct. That's correct.
And as I understand it, in his application, he listed his personal address as place of business, I guess.
That's correct.
Okay, go.
All right, thank you.
As part of this whole process with the application.
Well, those we're talking about that.
Sure.
That's the threatened breach that your client says violated the employment contract, correct?
It is, because the employment contract said you were to have no, from the end of your termination of employment for 36 months thereafter.
Well, no, I understand that, but I mean, that's,
That is, it's
that's
a
the
crux of it.
threatened, that's the threatened breach, and
Yes.
that is the only violation that we're talking about here. right?
Correct.
Okay.
Yes,
And in the first case, the court crafted a definition of threatened breach, correct?
in the
Essentially,
first trial,
first, no, with the first appeal.
in the first appeal, the court, yes, did come up with a definition of what a threatened breach would be for Dr. Hefner's employment agreement.
And it was something that would be actions that would reasonably then cause someone to believe an immediate breach would occur, or something to that effect.
If you could, I'll read it to you.
Yeah, go ahead.
It says, quote, under the common meaning of the phrase, quote, threatened breach, end of quote, in Hefner's employment agreement, a person must simply engage in some act that communicates or expresses an intent to violate the employment agreement. Hefner's subtle acts may establish this intent to violate his employment agreement. End of quote.
And there's,
But it has to be something that would lead to an immediate breach, or cause someone to think that there would be an immediate breach or an imminent breach.
Or that the harm would be imminent.
Yeah.
Yes.
I'm having a little bit of a problem filing for a trade name with an imminent breach of the non-compete. Can you tell me or explain to me why that is evidence of an imminent breach?
The reason why it's an imminent breach is once the Kansas State Board of Examiners approved that trade name application, it became effective immediately.
what became effective immediately?
His ability to practice as Hefner Family Vision LLC in Shawnee County at his address that he listed on his application.
The name became effective.
No, the name became effective, which allowed him to practice under that name.
Well, did he take any other steps to set up a practice, any place?
He had looked for office space sometime between middle of September and the end of November.
How do you know that? Is that there's testimony to that effect?
And depositions, yes.
Asserting that the looking for office space was a threatened breach?
It could be when you put the chain of actions that happen there. You're looking, you want to be bought out, you're looking for office space, you apply for a trade name with the SBEO, which is public record and goes into effect immediately. And it says, per the rules and regulations, that by making the application, the applicant certifies of their intent to practice at that location.
Within a certain amount of time, and he did not check the box that he intended to practice within a certain amount of time at that location,
He
correct?
did not, but as the Court of Appeals in the prior ruling already ruled, is that he was required to do that under the rule and regs.
Right, but as I understand it from reading the briefs, I mean, the regulations also state that if the person doesn't go into practice using that name, it lapses after 6 months, the name does, or the hold on the name.
If they don't use it for a period of 6 months, that's correct.
Right. Well, so it seems like the optometry board is anticipating that in some instances, someone may apply for a trade name and not actually go into business, because they've included a provision that it lapses after 6 months.
If they don't use it, right.
I understand. But that's a possibility. Again, and I'll go back to my question. It seems to me, and I set up a solo law practice at one point, a lot more work to close it than set it up. But having a trade name is a long way from having an up and running business, it seems like to me. And I'm having a hard time seeing how that is enough to fit the definition of a threatened breach that our court fashioned in the first case. And I would like you to explain to me, I hate the word nexus because it gets thrown around in the law, not very loosely, but how there is a sufficient nexus between having a trade name and violating that non-compete clause.
Well, the nexus is under the operating agreement, excuse me, the employment agreement that he signed. It was reasons and cause for termination if you competed in any way or had any connection with the ownership of a practice in Shawnee County, Kansas, or the contiguous counties.
Counsel, wasn't there some negotiations going on that non-compete clause could have been ignored if he did certain things?
Had he gone ahead and signed the agreements and consideration passed and those sorts of things, that was what was intended. However, those negotiations had stopped because December 1st was when this was all supposed to have happened.
When did
But
the,
at the time of him applying for the name,
Mhm.
he still had that option available to him, didn't he?
The option to sign the agreements?
Right.
Sure. But he didn't.
so the negotiations were still ongoing when the application for the name was put forth?
To the extent that everything was written out and waiting for him to sign, if you want to say that was still a negotiation when it was open, then you're correct.
So what indicates to you that the negotiations ceased?
Because everything was supposed to, we were supposed to have the agreement of separation, the exit agreement, as well as the new employment agreement, all signed, ready to go December 1st. And instead of going forward with that, he filed a trade name application to open this competing practice in Topeka.
Why are
And
these
never-
mutually exclusive?
Why are they mutually exclusive?
Right.
Because he had one employment agreement at all times. There was a negotiation of an exit agreement, which he never agreed to. So at all times, there was only one employment agreement and it binds him at that point. He decided not to do the exit agreement. That was
Made
his
you-
choice.
I'm missing the facts where he decided not to do the exit agreement.
Mhm.
But I think we still have the issue of an imminent breach. The breach as defined in the contract is has to do with being involved with the operations of an optometry practice. We have no evidence here of an optometry practice.
Well, you do, because it also says the ownership and operation of one. He can't have an optometry practice.
There's no evidence that he had an optometry practice.
Well, he couldn't have one until he got the trade name approved.
Mhm.
That's the pass, go collect $200 deal. Once he had that, it was open for him to do, as he testified at the first trial, to loco tenens, have a practice of loco tenens right there, meaning,
I know,
Have to
I
do
know
much.
what in locum tenens
I know,
is.
I know.
And
but
so,
I didn't, I had to look it up.
so is there evidence of in locum tenens contracts?
No, but he admitted that he could do that immediately from the house. Where he was allowed by
With
the
equipment.
SBO to have a practice under that name at that location. Which is also the thing you have to have when you go to file your LLC. Those papers that need to go to the court of the Secretary of State,
Right.
approved by the
Did I
licensing
miss the
agency.
Secretary of State filing for?
He never did it. And the reason is because on December 7th, he chose to resign.
By having the ability to do something, that doesn't necessarily mean he's doing it, does he?
Well, it doesn't necessarily mean that he's doing it, but he can do it immediately. There's nothing stopping him.
I thought the contract provision was that he couldn't practice. But you're saying that applying for a name, that violated it because he was practicing.
And he could practice there in Shawnee County.
He had potential.
Sure. And as he said, he could do local tenants immediately.
So the contract provision prohibited the potential to practice.
Well,
How did the trial court resolve this?
but the trial court resolved this both times, was basically saying the trade name application was basically a placeholder. And therefore, because there was ongoing negotiations and Dr. Deutscher for the corporation in good faith wanted that agreement to happen, that somehow that is a factor here. The fact that the employment agreement say and the redemption agreement say, if you violate paragraph 14D, which is either a breach or a threatened breach of the non-compete, then you lose, you surrender your shares, you forfeit any future payments from the corporation from any source. And of course, those are all valid and effective. The court made a big deal out of the fact that Dr. Deutscher at the second trial was asked whether this was an ace in the hole, and he said it was. But my point is that card, that ace was in that deck from the get-go with his employment agreement and the redemption agreement. The person who played it was Dr. Hefner. There was no way that Dr. Deutscher could have done that. And finally, because she believed that Dr. Deutscher couldn't have been threatened. Well, the standard for threatened breach isn't whether the person being harmed feels threatened. It's whether the person proposing to breach is threatening. It's what the standard is. It's a very, very low
Yes.
standard.
To the extent that a reasonable person would feel threatened by the threatening behavior of the threatener. And if you're in negotiations to part ways, is it reasonable to feel threatened by the filing of a trade name?
When you look at the nexus, that's how close it was within 36 hours of D-Day when everything was supposed to happen. I can't say that was still that negotiations were going on at that point.
Judges, do you have any more questions on this issue? Because I think issue number 2, we should move on to the fiduciary.
Very much.
issue.
On the fiduciary deal, it's important, I believe, to remember that claim as pled and always pled by Dr. Hefner, never amended, was that there was a fiduciary duty breach towards him because of the majority shareholders, Dr. Deutscher and Dr. Rottinghouse, having the majority shares. In other words, there was a majority block. Okay. In the first trial, Judge Watson in the trial court said that both of them were
Have breached that duty.
breached
In the
that
second
duty. And
trial-
in the second trial, she said, because Dr. Hefner was never a director and not involved in any of the decision-making regarding the corporation and Dr. Hefner, he had no fiduciary duty. And then released the claim.
Rotting House.
Thank you, Roger.
So I think we understand that argument. Your argument is that Dr. Hefner made an argument as to Rotting House and Deutscher. The court ultimately found only as to Deutscher. And so that is somehow impermissible.
Yes, because his whole claim was based on the majority block. When the court took Dr. Hefner's, Dr. Rottinghouse's 20 shares out of there, then that majority block dissolved. And therefore, how can you continue going on with this idea of the majority against the minority when there was no longer a majority? Dr. Deutscher, Dr. Hefner both had 40% of the interest in the corporation. Both of them were directors.
But the duty of loyalty doesn't require that it be a majority versus a minority.
Well, no, but the point being was as pled.
Okay, so the argument is
That once you took away the majority, this was the majority minority issue here. When you got rid of the majority, that block ceased, and you didn't have that at all.
so your argument is that the court was not permitted to have a finding different from how it was pled.
Correct.
And did you have any authority for that?
Because we look at what's pled. That's all the thing was that, and that's what the facts were, was that it's these guys against me.
So you didn't have the opportunity to present a defense as to that.
No. And I believe that because the majority dissolved, that the court was wrong in continuing the fiduciary duty claim against Dr. Deutscher. Now,
I'm sorry, you're running out of time. I just wanted to warn you, and some of that is because we took up some of your time with questions, so I'll let you wrap up. But with regard to this issue, though, is it your contention that you would have presented different evidence had the argument been different, or that somehow the duty of loyalty changed?
no, and the
Dr.
reason,
Deutscher?
no, because they were considered this block. Now, we put on all the evidence that we put on both times, as far as fiduciary duties and stuff. So what the court did is then say, well, then we're going to go against Dr. Deutscher on this breach of fiduciary duty thing on the prudent man rule, saying that, number one, it wasn't his decision to terminate Dr. Hefner was not informed. Well, when you find out from a member of the public that one of your shareholder members has filed an application for a trade name with the SBO, you check out on the website, yes, the application is there with the agenda. You wait until the next day after the meeting.
Seems like you're changing the argument. It's now become a sufficiency argument.
No, I mean, no, what I'm trying to say is that in the second trial, the court totally ignored the fact that Dr. Deutscher, being the only other director, was the only one who could deal with Dr. Hefner for the corporation. She conflated the fact that she missed that point, and then he was self-dealing, is essentially what she was saying. When in fact, he had his fiduciary duties to act in good faith with knowledge that a prudent man would have to protect the corporation, which also is these agreements to protect the corporation's interest. He's the only one who could do that. Okay. She said that basically he didn't pay Dr. Hefner because Dr. Deutscher wanted to increase his share of the corporation and get more money. Well, the evidence is, and through the bylaws and through the employment and redemption agreements, is all shares of a departing shareholder go back to the corporation. They become treasury shares. So in this whole deal, Dr. Deutscher, nor did Dr. Rottinghouse receive any more shares.
So
In the
Dr.
corporate.
Deutscher percentage ownership did not increase.
He didn't receive any more shares. His percentage of ownership increased only because it was a smaller number of shares outstanding. So he didn't get any more interest in the corporation. Secondly, she said this was a windfall to him. There was no evidence of a windfall to Dr. Deutscher. In fact, the evidence was the year after this termination, he made it basically the same after they had closed one of their 2 practices, laid off people, and the doctors worked a lot harder. That's not a windfall.
I'm sorry, your time is, but you can do a 30-second wrap up if you'd like, or you can wait.
Pursuant to the Court of Appeals prior decision, it's a very small, very low burden to prove threat and breach. It's an act. We have an act here of filing an application. It communicates an intent to compete with the corporation in the non-compete area. And under the rules and regs, it was a required intent. It's all right there. The corporation has a legitimate interest to protect its practice, its patients, and the patient base that it had. Dr. Hefner knew that. And therefore, that's why that covenant not to compete is what it was. He can't say that he didn't know what he was doing. He can't say that he didn't know he was bound by his original employment agreement, because as the Court of Appeals found the last time, he was asking to be relieved of it. So he knew that's what it was. So it binds him. So I think the trial court, the second trial, did not follow the instructions of the Court of Appeals, did not look at the evidence that there was, and instead focused on Dr. Deutscher instead of the intent and the actions of Dr. Hefner. Finally, I believe that Dr. Deutscher fulfilled his fiduciary duties and should not be personally liable for this damage award. Thank you.
Thank you. Counsel,
May it please the court, Roger Walter on behalf of the plaintiff, Dr. Hefner. Forgive me, I'm not sure of the protocol here. Is the appellee allowed to reserve rebuttal time or the,
not typically,
okay,
no,
it didn't hurt to ask.
doesn't hurt to ask.
Let me begin by a general observation. I think the defendants here are grasping at straws and making contorted arguments just to avoid paying Dr. Hefner what he's owed under the agreement. The defendant's appeal presents 3 challenges, as you know. They object to the court's finding that there was no threat and breach. They object to the court's finding that defendant Deutscher breached his fiduciary duty he owed to the plaintiff. And they object to the court's finding as to damages. All 3 of these are factual determinations. And I don't think I need to remind the court the standard of review on those factual determinations.
Could I jump to the second issue, the fiduciary duty?
Yes.
And I will admit that I am not an expert on corporate forms and who owns what duties within that. Can you define for me the precise fiduciary obligation that you contend Dr. Deutscher owed, and in what capacity? Was it as a director? Did he owe it to the corporation and in turn as a pass-through to Hefner as a shareholder, or was it between 2 directors? I need some clarification in my mind about precisely what the duty was and who it was owed and why it was owed.
Yeah, I think the expert in Kansas on fiduciary duty was Webb Hecker.
He's not here. so
He's not here,
you.
but I read all of his stuff, and it's a tripart duty, and the duty here involved is the duty of loyalty.
Well, all fiduciary duties do that. I mean, what is the specific
Duty to
relationship?
act, the duty of loyalty is owed both to the corporation and to the shareholders. And Dr. Deutscher owed a fiduciary, Dr. Rottinghouse and Dr. Deutscher, when they collectively combined to act as a majority block, in this instance, owed a fiduciary duty to Dr. Hefner. Dr. Deutscher, as a director of the corporation, owed a fiduciary duty
To,
Dr. Hefner and the
as,
corporation.
okay,
And Dr. Deutscher, as the president of the corporation, an officer, owed a fiduciary duty. I had some difficulty sorting out exactly how Dr. Deutscher fired Dr. Hefner.
I mean, under what authority he acted.
Authority under the bylaws, and there was confusion. And I wanted to know whether there was a directors meeting. I went through all this in my cross-examination of him. Dr. Deutscher was very insistent that he fired Dr. Hefner as the president of the corporation. So I did not limit my claim of breach of fiduciary duty to any particular capacity. I just said it's clear that a fiduciary duty was owed, and I don't think there's any dispute as to that. The question is, was there a breach?
Well, in this case, the breach is terminating him for something that wasn't a violation of the employment contract, correct?
Yes, that was the decision. That wasn't in the best interest of the corporation. That wasn't in the best interest of Dr. Hefner.
Well, how could it not be in the best interest of the corporation? They didn't have to pay him a bunch of money.
Well, because the corporation is liable for a breach of contract in those circumstances. That was an illegal act. And then you get into the, I'm sorry.
No, go ahead.
So the fiduciary duty is the duty of loyalty owed to the shareholders to act in the best interest of the corporation and the shareholders. That takes precedence over any self-interest an officer or director has. And so, we get into the business judgment rule that says if directors are acting in good faith with sufficient information and not subject to any self-dealing conflict of interest, there's a presumption their act is valid. However, if the director has a self-dealing financial interest in the decision or the decision maker, then the transaction is subject to strict judicial scrutiny.
Now, the district court spoke to that, did she not?
Yes. Yes.
Tell me about that.
Well, it seems to me very straightforward, inescapable conclusion that the defendant and the plaintiff owned 80% of the corporation. Together, they split 80% of the profits after everything was done. If Dr. Deutscher took an action to eliminate Dr. Hefner and did it in a way to avoid paying him $1 million in his redemption compensation, he saved the corporation and himself $1 million. How can that not be in his financial interest? After Hefner left, after he got rid of Hefner, Deutscher owned 70% of the corporation. If you avoid the corporation paying $1 million it owes, you've saved yourself that. But Dr. Deutscher financially benefited from this. I mean, this whole
Address the argument that it wasn't Dr. Deutscher didn't benefit more than any other shareholder because the action affected all sharedholders equally.
well, there are only 3 shareholders.
I'm aware.
Okay, so after this was done, after Dr. Hefner was taken out, Dr. Deutscher owned 70% of the corporation. His compensation in 2016, when Dr. Hefner was there, was about $470,000. His compensation next year was over 700,000 or right around that. So how can you say he didn't benefit? He benefited
Well,
because
the benefit could have resulted from something else. But the idea is, our case law has addressed this in a way where, when the act applies to all shareholders, then maybe not.
that case cited by the defendants in their brief, it really supports our position because
Tell me.
that case involved a group of doctors who bought a competing interest in another hospital. And by doing that, became ineligible to be directors and shareholders in the subject hospital. So they were removed, and all of the shareholders, their shares were redistributed or taken back in. But all of those doctors received fair compensation for their interest. Here, Dr. Hefner got zip.
What's your response to the argument that the defendants make that your theory actually was essentially a civil conspiracy between Deutscher and Rottenhaus, and the judge cutting Rottenhaus loose with no fiduciary duty somehow absolves Dr. Deutscher of liability?
Well, we had multiple theories for claiming the breach of fiduciary duty. One was, first of all, I guess you look back and how was it that Dr. Deutscher was able to concoct this theory and fire Dr. Hefner when he only owned 40%?
Well, I mean,
Yep.
they're arguing you won on a theory you didn't advance.
That's
What's the
not true.
response to that?
That's not true. My theory was a breach of fiduciary duty. And that fiduciary duty was owed in multiple capacities. It was owed as an officer, it was owed as a director, and I contend it was owed as a majority shareholder, because Dr. Rottinghaus and Dr. Deutscher signed the termination letter. They had, I mean, if you think about it, you probably needed a 60% interest to take action and do what the corporation did. Now, the court let Dr. Rottinghaus off. Dr. Rottinghaus, the evidence showed he was a passive participant, maybe a victim in this whole thing. He didn't really make the decision. Dr. Deutscher made the decision.
Well, didn't the court, though, determine that Rottinghaus didn't have a fiduciary duty?
Maybe so, and that could have been appealed, and we chose not to appeal it.
Okay.
I think I maybe take issue with that finding of the trial court, but life is short. The reality is Dr. Deutscher was a responsible party that really took this action, and he is individually liable for a breach of fiduciary duty. So it wasn't civil conspiracy, Judge Atchison, it was breach of fiduciary duty.
Well, no, I understand that, but if you have two people acting in concert there and there was a civil wrong, you would spread the liability that way, but I'm not sure that that absolves the wrongdoer if the other isn't a wrongdoer.
Right.
I mean, I guess, I mean,
Right.
but
Counsel, I wanted to ask you how we should consider the district court's findings concerning the credibility of various people involved in this case.
It's not the role of the appellate court to reweigh the evidence or assess the credibility of witnesses. That's the trial court's function. You didn't see the case presented. And I think those are the rules. The standard of review is that, you have to ignore conflicting evidence or possible conclusions that could have been drawn from the case. You can't reweigh the evidence. You can't reweigh the credibility of the witnesses. Your task is to look at the decision that was made and see if that decision was supported by substantial competent evidence. And here it was.
Do you agree that some of these findings go clearly to the motive of one of the doctors of self-dealing?
The breach of fiduciary duty
Yeah.
finding made the obvious decision that the decision made by Dr. Deutscher when he terminated, keep in mind, the only way the corporation could avoid paying redemption compensation was to find a breach of the anti-compete clause or a threatened breach. That's the only way. When Dr. Deutscher did that without proper justification, the court found that there was no threatened breach, and that's amply supported in the evidence. And therefore, the corporation breached the contract and should have paid him the $1 million or the redemption compensation that was owed. When Dr. Deutscher did that, he saved himself a lot of money There was an obvious reason why he was doing that. He didn't want to pay Dr. Hefner his redemption compensation. And that decision benefited him financially. That is as plain as a nose on my face, Your Honor.
Okay, there is a third argument that no one has addressed quite yet, and it is the damages in this matter. And the parties had quite different assessments of the value based on quite different processes.
Okay.
And appellants are taking issue with the district court's decision to go with your expert.
The redemption agreement was pretty clear. This contract was signed in 1997. Up until 10 years, up until 2007, the redemption compensation owed when a doctor left was a set fixed price per share. After that time, it was clearly the value of your stock plus other interests in the corporation based on practice value. Dr. Deutscher's expert simply valued the value of his stock.
Using what number?
Well, he used historical transactions for buy-in prices.
How many transactions were there over the history of that corporation?
There were transactions back to I'd have to look at that. If Dr. Reynolds was the original doctor, and it went back a long time. But the buy-in price, as you know, often is nominal. It's not related to the real value of the corporation as an ongoing business. It was simply, I mean, I had to buy in stock when I became a partner of my firm. That was set at a nominal price. It doesn't relate to the value of the business. One, and two, the revenue ruling that was cited, has been cited here, cautions against valuing small, closely held corporations based on historical stock transactions because there's no established market value for the stock. And moreover, the redemption agreement didn't limit compensation to the stock value. At the end of the day, Mr. Klinkenbeard's valuation for the stock was a little more than what Dr. Hefner paid for it when he bought in 20 years ago. And that's not the value of the business. Our expert worked for a company, was a chief financial officer of a company that did this work nationwide, limited to optometry practices. He had appraised over 200 optometry practices in the last 3 years. He used 4 established valuation methods that people use to appraise the value of business.
And did he embrace the revenue ruling from the?
Yes, he did. He didn't use stock value. He used asset-based value, capitalization method of earnings, discounted cash flow, and debt service method. And then
Like all economists, he came up with 4 different answers.
4 different answers. And the judge asked him, Mr. Work, what do you think is the best valuation? And he said, well, people tend to think the discounted cash flow basis is the best method. So that's what the court adopted. And then she subtracted the value of the liabilities, added in the cash and accounts receivable, and even added in the amount owed to a previous doctor who retired, even though it wasn't carried as a liability on the books of the corporation. She gave him the benefit of the doubt. And then she took that number and multiplied it by 40%. Not only did the plaintiff's, the defendant's expert improperly limit his value to stock only, he then applied a minority discount, which the Kansas Supreme Court has said you can't do when the purchaser of the stock is the corporation or the majority shareholder. That's the Arnaud decision cited in our brief. So the defendant's expert's value was egregiously low. And it was limited to simply some sort of value of the stock, arbitrary value of the stock. And it wasn't based on the practice value.
Or says something about expert witnesses, they could differ by 90% on this, but
Well,
why, I mean, why, yours,
the old saying is, what it takes to be an expert witness is a briefcase and more than 50 miles from home. I jest, no, you always, obviously.
what deference do we owe the district court on that decision? I mean, her choice to credit your expert and not theirs.
Well, you have to ignore the conflicting evidence and accept the court's credibility, that how it weighed the expert. I think that's obvious. And then you have to look and see, did the court make a factual finding based on substantial competent evidence? And I don't see how you can come to any conclusion, but that she did. She had court's decision is, what is it, 40 some pages. She did a heck of a job. She laid it all out.
And the parties could have negotiated a price for this.
They could have,
Correct?
they could have.
And in the negotiations prior to getting to the point where Dr. Hefner was going to not compete, did they negotiate a price?
That's an excellent point. Thank you. The original proposal by Dr. Hefner was two options. He said, you can buy me out for $100,000 for my stock and $750,000 for the remaining interests in the corporation, $850,000. That's what he offered him. Or option two, you can pay me $100,000 for my stock, waive the non-compete, and I take my patients and open a competing practice in Topeka. Those were the two options. Dr. Deutscher jumped at option two. He didn't want to pay him any money. He was willing to do that option. So yeah, Dr. Hefner proposed at the outset, you can pay me $850,000 and I'll go away. That's, and 10 years earlier, when Dr. Cecil Kohaki retired, he got an amount comparable, roughly comparable to what the court ruled here. He got 150 plus almost 700,000. You can, I think there was a substantial competent basis for the court's determination of the value of the optometry practice. This optometry practice routinely produced between $2.8 and $3 million in revenue annually. And to say that a 40% interest in that ongoing enterprise was worth $100,000, that's not credible. Any questions on the threat and breach? I think that I got a whole spiel to go through on that if you want me to. But if you have to look at a threat and breach, you have to look at what the breach was. And the breach was actually opening a competing optometry practice. So a threat and breach means that had to be an imminent threat. And Dr. Deutscher admitted, let me remind you what happened. November 29th, my client applied for a trade name, didn't check the box, wasn't sure he was going to use it, but did it out of an abundance of caution because that option was under negotiation.
He was thinking about teaching.
He's thinking about teaching. A few days earlier, he'd asked Dr. Deutscher to reconsider and buy him out at a discount, and Deutscher says no. So he still hadn't decided, so he did it just because he wasn't sure what he was going to do. That Mr. Engel, Dr. Deutscher calls Mr. Engel and said, hey, he applied for a trade name. And he said, don't do anything, just wait and see what the board does. And then the board granted it. And then it was clear to me. And and Dr. Deutscher admitted this on cross-examination. You really thought you had an ace in the hole here because you weren't sure he was going to take the option 2 deal, but you wanted him to. And now if he didn't, you had him. because they believed that that trade name application was a completed breach. And nobody ever raised a point about that until December 6th, when Mr. Engel called my,
But under your negotiations that were ongoing, Dr. Deutscher wanted Dr. Hefner to take the deal where he would open up
to the very end,
eating business.
to the very end. That
So-
never stopped. And then on December 6th, Mr. Engel contacts Mr. Hayes, my former partner, and says, hey, what's he doing? He breached the agreement because he applied for the trade name. Mr. Hayes says, no, I don't agree with that. But that was on the 6th. On the 7th, Dr. Hefner decides, I don't want any part of this. I'm leaving. Tenders his resignation. Says, you buy me out, which was his option under the redemption agreement. And Dr. Deutscher admitted at that point, he knew Dr. Hefner was no longer considering option 2 or opening a practice in Topeka. He no longer perceived any threat. He admitted that. He admitted that. And then they fired him 3 days later on December 10th.
Was there evidence in the record that the request for the trade name was withdrawn or canceled? Or
Yes,
when did that occur in this chronology?
January 3rd.
And when is that relative to the time that your client was ostensibly fired?
Formal letter of termination was issued on January 7th,
It was after.
after he withdrew the
Is there
trade.
evidence that Deutscher knew that it had been withdrawn? Or
No.
is that, I'm sorry?
No,
Okay.
Thank you. Okay. Council, you have 5 minutes remaining, because that's what you requested, but we ran way long earlier, so I'll try to make sure we stay on time for this one.
Okay, as far as the damages, or let me make it very, very clear. He just made a misstatement that's saying under the agreement, that you had to have opened up an optometry practice for there to be a breach of the employment agreement.
Yeah, we
That's
understand
not
what a
true.
breach.
It's a threatened breach. Okay. You want to talk about also these, the idea Judge Hill mentioned that Dr. Hefner was also looking at a teaching position when these negotiations were going on. We didn't know that until after this case was filed. When he resigned on December 7th, his letter, basically it's the letter of resignation. It doesn't tell us what his future plans were.
Did he request a buyout in that letter?
He just asked him to be given what he was entitled to under the redemption agreement for his shares and stock. But he didn't say anything about this practice that he'd been authorized to open if he wanted to in Shawnee County. And of course, he left that trade name effective until January 3rd, but we didn't know that. We learned that after this all fell apart. So as far as you're looking at what his intentions are, this whole thing, his act and what did he communicate to us was getting ready to open up a practice in the non-compete area. When he didn't agree to what the agreement we'd already struck, then we're back to the only agreement we have, which is the employment agreement. Now, as far as valuation, there was negotiations from the get-go, and it went back and forth. But as Mr. Walter probably told you, he offered $100,000 and he takes his patients and leaves. We agreed to that. Every other negotiation thing we came up with, we gave to him, but it was his number, $100,000. The contract says if you're going to have to pay on a redemption, it is the value of his shares and other interests in the corporation based on the then existing value of the corporation. The December 31st, 2016 balance sheet of this corporation said it's worth $300,000.
I understand, but it says other interest in the corporation. If he were to leave with the $100,000 price, he would also get his patients and the ability to work in Topeka.
Not true. Because under the employment agreement, it's very clear that those patients belong to the practice. They always were, and that's why you have the non-compete in the first place. And he knows it. So those were out his. He didn't build up this practice. He got, when he came in, patients from doctors who were leaving.
But you
And house
said
calls.
you agreed to him taking patients
No,
for the
he
$100,000.
could go elsewhere and there would be letters for patients to decide where they wanted to go. But it was $100,000 for everything. So also, you look at the present value of the corporation, 40% of $300,000 of the value of the corporation is right about 115,000 or whatever. That was another value. I was right out there. Mr. Klinkenberg, our expert, looked at almost 60 transactions of shares in this corporation between shareholders that he believed were arm's length transactions over about a period of about 40 years to come up with the value. And why is it low? The reason is low buy-in costs that they took out these three doctors habitually. The process was you take out almost every dime of profit every year. Therefore, they all became very wealthy. You buy in for $100,000, your return on that investment over your years of practice ends up in the millions. That's why the corporation didn't have really many assets, had no retained earnings. That's all it had. So you look at that valuation, and he came up from the historical values. Now, revenue ruling 5960 says it can be used to value shares in closely held corporations. And one of the factors there is the fact that there's no market for the stock because there's only one place to sell it. In this case, it's the corporation. Shareholders can't even sell shares between them. The biggest problem with their expert is his premise was that the practice would be sold and purchased by a private equity company, which is illegal in Kansas. Kansas law says only licensees are able to have any interest in an optometry practice, KSA 65-1502. That is illegal. Also 65-1524, no corporate practice of optometry in Kansas. So that whole premise was illegal. Also, big expert here did all of these supposed evaluations across the country. He could not give us not one comparable sale where any of these 4 different methods that he averaged was used and came up with. Not one.
I think your time is expired. Can you wrap it up in 30 seconds?
I can wrap it up. Don't get me wrong. Dr. Deutscher did not violate his fiduciary duty. He has a duty as a director to the corporation to act in good faith and what a reasonable person would do, knowing the information that he had. His first duty is to the corporation, as are these agreements. In this case, he was the only one who could deal with Dr. Hefner. And there is no evidence that he didn't want to pay Dr. Hefner, that he was saving all this money, that it was a windfall to him, that it wasn't a benefit to everybody else. Also, he mentions the Arnaud case, and as you already know, that was a certification case dealing only with reverse stock splits, not even irrelevant in this case. So you look at the 4 evaluations, even the expert they use, his boss came in with a valuation that says these practices aren't worth what they used to be. 65% of the prior year's net revenues, less debts, which would have come up to about a value of $135,000. So there's 4 valuations, all within about $35,000. And then another one that's over $1 million. That doesn't work. Thank you.
Thank you, counsel. We will take this matter under advisement and get back to you timely.